we have a client that was interested in purchasing a colorful company that had a lot of different IP and patents, and the thing that came out when they were pretty far down the road that Matt had to come in and help clean up was that they hadn't been putting all of their IP into the name of the company. There were individuals who had things that needed to be tracked down. And at that point, again, the client had not since they didn't find out about it until a point where they were negotiating price, it really did drive down the price that they were willing to pay, which is fine. But I mean, really, ideally, you want to go into a transaction and know that what your client is buying, they're actually buying.
In this case, we were representing the buyer.
Yeah.
And we were doing the due diligence on this company and realized, oh wow, there's a lot of individuals who were founders of the company. There were 3 or 4 or 5, maybe 5 individuals who were founders of the company. They had IP in the US and foreign countries. Mm-hmm. Some of the founders were foreign nationals from other countries. And it turned out that some of the patents and even the trademarks were owned in the name, as you said, were owned in the name of those individuals. The individuals never transferred their rights to the entity. We were telling our client who's buying this entity, well, the company actually doesn't right now own those patents. It doesn't own those trademarks. Mm-hmm. They need to get that cleaned up. As I said, we were representing the buyer, but again, probably lots of heartburn on the seller's side, and it did end up in significant write-downs in that deal.
Yeah. One of the things that we would tell all of our clients right off the bat is you need the IP and any other thing that's valuable to the company to be in the name of the company. You've got to track the ownership to the entity. It shouldn't be housed outside in individual founders. If you're deciding to start a business, run a business, have a business, you need to treat it as a third party, as its own existing, breathing thing, and give it the right to ownership so that it's not an issue down the road. Because you move along, you forget, you don't think it's that big of a deal, but then it always winds up coming out. It's much easier to just proactively be taking the steps to have the ownership properly documented.
A lot of people just assume, well, I've got this company, maybe it's a single member LLC, and I'm doing business and I've developed this IP, it must be the company's. Mm-hmm. But it's actually, so let's just take a patentable invention, for example. Unless and until the inventor, the human being who invented that invention, that patentable invention, assigns his or her rights to the entity, it stays with the inventor. Now, there might be some exceptions to that, but the same is generally true for a copyright protected work product. You got to get it into the entity by having a pretty simple agreement. That's another point. I think it's not complicated. It's very simple. It's just going through those steps and taking those steps to make sure you've got your house in order in terms of owning what you think you own.